Hello and welcome to part 1 of the US Law Essentials video series on improving your performance on the law school persuasive memorandum, usually a memorandum of law. Typically, this will be a memorandum of law in which you're asking an appellate court to either affirm or to reverse a decision of an inferior court. We'll be focusing on 3 main topics in this first video: managing your time, research and case summaries, and finally, outlining. And along the way, we'll have a few tips and tricks. Remember, these are just tips and suggestions. You've got to follow what your instructor says. And that's a lot like real-life lawyering, because in real life, judges and law firms are going to have rules on final work product, and your success will depend in many respects on following those rules. So don't get your judge angry. And here's an important cautionary note. Everything you see in this video is really just an example. So please don't rely on any content in this video as being accurate with respect to the law for any purpose, whether it's for your own academic or research purposes, or whether it's for any type of legal purpose. On your law school memo, typically you're being graded on 3 different categories: organization, persuasiveness, and professionalism, even though the actual rubric is going to look a lot different from this. Organization is really quite important. Your professor, your instructor is going to be looking for clear organization, and that's because every brief has sections. For example, every memorandum of law should have a table of contents, a table of authorities, usually a procedural history, a statement of facts, and your instructor is going to expect you to have each of these categories in the correct section. Likewise, the legal argument itself also needs to be logically divided into different sections. Your professor is probably going to expect you to have well-written headers at the top of each section, and this type of organization is going to be extremely helpful for your grade. Because this is a memorandum of law, it's got to be persuasive. And your memo is going to be a lot more persuasive if it's easy to read and if it makes the reader feel smart. And what you're going to find is that type of persuasiveness is directly tied to organization. That is, if your memorandum of law is organized well, it's going to be easy to read, the reader's going to feel smart, the reader's going to like you, and you'll get a better grade. And this last category, what I'm calling professionalism, you need to follow the instructions of your professor. So make sure you're doing exactly what the professor is telling you to do on this assignment. And also included in professionalism are accurate citations that appropriately support the facts and the law within your memorandum of law. Here's what's not being graded. And I do see a number of students who come to me who are thinking that they've got to find some sort of secret hidden case. And if they can just find this secret case, then they're going to get a better grade because the professor is going to say, aha, you found the hidden law, now you get an A. It doesn't matter what else is in your memorandum of law. That hidden case doesn't exist. And as a student, you're wasting your time. Don't spend all this time trying to find this secret case because it doesn't exist. Instead, you've got to manage your time better. And that takes us to our first major topic, which is managing time. And something that I do see with a fair number of students is just inadequate time management. And while your individual situation might differ and your individual assignment might differ, I really only recommend spending about 20% of your time on research. And in research, I include reading the facts and the law of your own assignment carefully. And then you're going to be putting an additional 10% of your time writing your summaries of these cases. And that leaves you with still a good chunk of time to prepare a really good outline. and then you're going to spend your next 20% of your time writing your brief. And by percentage, most of your time should be spent rewriting the brief. And notice that I said rewriting your brief as opposed to editing, because probably this is not going to be just minor editing, but it's probably going to be significant rewrites as you correct and improve your memorandum of law. Where students often go off track is they spend something like 70% of their time doing the research. And often this research is looking for that mysterious, non-existent hidden case. Then they spend their next portion of time frantically writing their brief, and then in the little time that they have left, they'll do some minor editing. And as a result, there's no outlining before writing the brief, and then there's no time spent rewriting the memorandum of law. Instead, I recommend that you focus your research time so you have enough time to outline, write, and rewrite your memorandum of law. So as we get started, let's take a look at a sample background. And obviously for an actual assignment, you're probably going to get a lot more facts and a lot more detail, but this will be enough to get us started as just an example. We'll say that the defendant was convicted of bank robbery in the United States District Court for the Southern District of New York. And we'll say that the defendant is Buddhist, Asian, and he's from a country called Wrangle. I just made up that country. And we'll say that the government exercised a peremptory jury challenge to exclude a Buddhist monk who was from Wrangle. And we'll say that was Mr. 421124. And this potential juror worked at a Buddhist temple that was attended by the defendant's family. Now, counsel for defendant timely objected to excluding Mr. 421124 based on race, and then the defendant moved post-trial on grounds that the exclusion was unconstitutional and improper. The government consistently argued that the challenge was based on the potential juror's association with the defendant's family and based on the potential juror's religious beliefs. The defendant's objections were overruled, he was convicted, and his post-trial motions were denied. So now, our assignment is, on behalf of the government, we're being asked to respond to the defendant's argument on appeal that the district court erred because the government unconstitutionally excluded a Wranglese juror. And again, this is a made-up country, but we'll assume that this was an Asian juror because of his race. And the defense is relying on the Batson v. Kentucky case, I apologize. And we're being asked to also respond to the defendant's argument on appeal that the district court erred because the government unconstitutionally excluded this juror because of his religion. Taking a moment, you might be familiar with a quote by the writer E.L. Doctorow in which he compared writing to driving a car at night in the fog. And the writer observed, well, you can never see further than your headlights, but you can actually make the whole trip that way. And this process is going to be similar. At first, it might seem hard to know where you're going, but if you go step by step, you will be able to get through the entire assignment, even if you're not exactly sure what the destination looks like at this point. So let's take a look at some of the steps you can go through on your research and your summaries. And before we get too much into detail, I want to talk about one trick you can use to make things a little bit clearer for this car driving at night through the fog. What I encourage you to do is to go online, and you could use your law school's subscription services, or you can just do a Google search, and you can find really good examples of memoranda of law written by students and attorneys. Some of these are excellent, some you might not like. But what I encourage you to do is notice what these students and attorneys do in their memoranda of law. And by way of example, I have a portion of a memorandum of law written by a Supreme Court justice, although this was while he was still a practicing attorney. And I've changed some things a bit. When you open this attorney's memorandum of law, you'll see the first major legal point is The Environmental Protection Agency has no authority under the Clean Air Act to invalidate a state's determination of best available control technology that is based on statutory factors. Now, you might or might not know anything about this legal topic. But right underneath that, the attorney says, as we explained below, the plain language and the legislative history of the Clean Air Act makes clear that this BACT is a determination to be made by the states, and the EPA has no authority to second-guess that state's determination. Below that, our very first major subheader is A. Plain language of the CAA makes clear that BACT is a determination to be made by the states on a case-by-case basis. And notice how logically this heading links up with the language from the prior paragraph. Here, the lawyer tells us that he's going to be talking about the plain language, and right underneath that is a header that talks about the plain language. And the first sentence introduces the plain language of the CAA. Now, I don't really know if the attorney is right or not, but I'm starting to feel smart because this is organized so logically. And no surprise, the next major header is B, which talks about the legislative history of the CAA. Again, it just links up so logically with that prior paragraph. Now, if the citations support what this attorney is telling me, I'm going to be persuaded because the organization is so logical. Here's another example. This is also an appellate brief to the Supreme Court of the United States, and the attorney writes, trademark registration is not a government subsidy or government speech. You might or might not be an expert on trademark law, but notice how our next major subcategory, 1B1, trademark registration is not a government subsidy. It links up so nicely with our heading B. And no surprise, B2 says trademark registration is not government speech. Again, links up so nicely with our prior heading. This type of organization is logical, and it's something that you're going to be using to get the best possible grade on your memorandum of law. Another suggestion I have is start writing as soon as you can. And while you might not be writing the actual memorandum of law, you can immediately create your first document, which I'll call an issue document. And that's simply listing what you're going to be researching from the very beginning. You're getting words on paper and you're getting started. I encourage you to use the assignment that your instructor gave you itself as a guide to create these issue topics. Usually there'll be at least 2 major arguments. Sometimes there'll be 3, or perhaps there'll only be 1. But just looking at the assignment, you should be able to get these major topics you're going to research. And actually, as you start to look at cases, you're even going to see immediately some sub-arguments that you're going to quickly realize that you have to research. So based on our sample assignment, you could write down point 1 that I'm going to research. Trial court didn't err based on the prosecutor's exclusion of the juror of the same faith as the defendant. You can really write this before you even get started because that's what the assignment tells you need to research. Likewise, you can probably put down a point 2 that the trial court didn't err based on the exclusion based on race or because he was born in the same country as the defendant. And below that, I just wrote down a series of sub-arguments that you might not know immediately you're going to need to research, but as you look at the cases, they're probably going to jump out to you. For example, you'll probably see immediately that there's an issue based on whether or not an exclusion for religious reasons is subject to the plain error standard or some other standard. Another important point is you've got to read your cases and relevant statutes. If you're trying to save time by not reading the cases or reading the statutes, nothing else is going to help you. You really have to read the cases and understand them. And you're also going to really have to review the facts and the law within your assignment. In the end, you might end up with about 5 to 10 cases or 1 or 2 statutes, Make sure you read them carefully, and in the long run, you're going to save time. Remember, don't waste your time looking for that secret case that's hiding somewhere it doesn't exist. Do your research and summarize, and make sure you're summarizing as you research. And I'm going to show you a few tips on how I think you can summarize the cases that you're reading in a way that will be useful for your memorandum of law. Keep in mind, though, that not all cases are equal. Appellate level cases are usually more persuasive than trial level cases. Binding authority is almost always better than non-binding authority, and you'll want to rely on cases in which your side wins. So if you're representing the government, you're going to want to find cases in which the government prevails on appeal. So by way of example, if we're writing a memorandum of law to the Second Circuit, lawyers and students should be looking for Second Circuit and Supreme Court cases. If your assignment requires you to advocate for the plaintiff appellant, you'll want to rely on cases where similarly situated plaintiffs prevailed on appeal. Now, of course, you can't ignore cases that are bad for you, but you'll have to read them and be prepared to distinguish those cases that go the wrong way. So what do I mean by summarizing? When you're summarizing cases, it's kind of like photographs from a trip, and it's your way of making sure that you remember certain things. I guarantee you that before your research is finished, you're going to be forgetting key points from some cases, and you're going to be remembering key points from certain cases that are actually non-existent. And I think our brain does this because our brain hates ambiguity. So your brain is going to try to minimize ambiguity by misremembering things and to make your argument more convenient. To avoid this, you're going to have to somehow take notes and memorialize key points as you go along. And here's how I suggest you do it. First, for each case, put down the name of the case and the correct citation. We're always going to want to have correct citations early because it's going to save us a lot of time in the long run. Next, I suggest you have something that you can call a case history, just letting us know how this case got to this court. So in this case, we are looking at Batson v. Kentucky, and that was a decision that reversed and remanded a case that came from the Supreme Court of Kentucky. Next major category should be the holding and the rationale. This is where you talk about the decision of the case and how the court applied law to facts in that case. So one key point that I'm giving by example from this case is, on a timely objection, if the trial court determines that the facts establish a prima facie case of race-based discrimination, then the prosecutor has to come forward with a neutral explanation for excluding a juror. And again, I'm going to make sure I have the correct citation because I'll need that later, and this way I can always find that point. I might add another additional point to my chart, so the defendant has to make the prima facie case first, and after that, the burden shifts to the prosecutor. And here's my citation. The next category is important because here you're going to see how this case that you research relates to your assignment. And I'm calling this notes. The student in this assignment might want to note that the defendant timely objected only based on race in this assignment, but did not object based on religion. The student also is going to include a reference to where he knows this fact from the assignment. Here I just wrote R24. R will stand for record, page 24. Now it's possible your assignment is organized differently, but you want to make sure that your notes reflect where you got this fact from, because you're going to want to be able to refer to it easily and accurately later. The student goes on to note that Batson is silent as to preclusion of a juror based on religion. And I'd like to continue just a little bit more on these case summaries or case charts, because writing things out in the summary is the student's way of showing herself that she actually understands what it is that she's researching. Because if you can't write it, it means you don't understand it. And this is the place to begin writing it out to confirm that you understand it so you can argue it in the memorandum of law. So we're going to say that this student is continuing her research, and she sees that to establish a prima facie case of racial discrimination in seating a jury, the defendant has to prove that, first, he's a member of a racial group and that the prosecutor exercised peremptory challenges to remove members of that race. She sees that the court says that peremptory challenges are a practice that permits those who want to discriminate. And finally, a prima facie case requires showing that facts and other circumstances raise an inference of exclusion based on race. And now the student continues her research because she wants to see what are examples of other relevant circumstances, and she sees that can include a pattern of excluding jurors based on race, and also we can look at the questions that were asked during voir dire. And again, she includes specific references, specific citations to the case. Furthermore, the student is going to continue with her notes showing where and how this applies to her own assignment. In this case, the defendant ought to be able to satisfy points 1 and 2 as to race, but as to the religious-based exclusion, well, the case Batson v. Kentucky seems to be silent on that. She also realizes that the point of contention for this assignment is going to be whether there are facts and other relevant circumstances that raise an inference of exclusion based on race. And she's going to argue that there is no prima facie case of discrimination because the prosecutor didn't object to a Rangolese woman serving as an alternate juror, and she's going to argue that the prosecutor asked race-neutral questions during voir dire, and she makes sure to include citations to the record so she can easily and accurately find it later. Double-check the citations periodically. And what I mean by double-checking citations is to make sure that they're spelled right and they accurately support the statements of fact and law. By way of example, here we have some reference to relevant circumstances and a citation to the Batson case. The citation refers to a pattern of excluding jurors based on race and questions asked during voir dire. Well, student gets the case and she sees on page 97 the reference to a pattern of strikes against jurors based on race, and she also sees that the court can consider questions during voir dire as evidence of discrimination. Further, she wants to make sure that the spelling of the case is correct. She wrote Baston instead of Batson, so she corrects that. And now, as she goes on to her outline and memorandum of law, everything is as accurate as it can be. Another legal point that your instructor might not want you to overlook is the standard of review. That is, how is the appellate court reviewing the lower court's decision? Is it based on plain error, de novo, abuse of discretion? And again, what your research reveals should be placed in your case chart. So in this case, the student was researching what standard of review should apply to an exclusion of a juror based on religion, and she found a Seventh Circuit case, and she has the correct citation for that case. And in her summary, she notes that because religious-based exclusion is an unsettled area of law, that a plain error standard should apply. And her notes then reflect that because the defendant did not timely object to the religious-based exclusion, this would seem to support applying the plain error standard. But she should also consider, well, what is the plain error standard? So she finds a Supreme Court case, United States v. Olano. Again, she makes sure she has the citation. And here she writes down how the court defines a plain error standard. And notice how some points that she puts down here touch off other areas of research, because she sees that the court says that a plain error should be something that affects the fairness, integrity, or public reputation of a judicial proceeding. So she's going to keep asking herself, well, what does it mean to seriously affect the fairness of a judicial proceeding? And that could just be another area of research that she can put into this case summary. So when is your research complete? The research is probably complete once you've got appellate level cases that provide you with the governing law for each issue. And you want to have cases that present facts similar to your own assignment. So these should sort of be, aha, that sounds like my case. And you'd want to be able to rely on them if the case goes your way. Of course, if you find facts and cases that are troublesome, well, your adversary will probably be citing them, so your instructor might expect you to distinguish them in your brief. You'll know that your chart is complete if you have enough information in it that another student or a lawyer would be able to draft a reasonably good memorandum just based on your research. So it has to be that clear, because eventually you're going to be looking at this later, and it has to be clear enough for you. And you might think that you're going to remember everything and understand everything that you put in the chart. You probably won't. So think of putting in enough detail that if you look at it a few days from now or a week from now, you'll understand exactly what you're saying, and your citations are so accurate, you'll be able to find everything that you need. You're going to be really pleased if by the time you finish your case summary, 99.9% of your citations are already accurate. And after that, you'll be able to proceed to outlining. Outlining is our next major topic. The outline is your document that details the order of everything that's going to be in your memorandum of law. You will almost certainly be revising the outline from time to time. The outline is not just general ideas of what you want to talk about. The outline is going to be detailed enough that eventually the table of contents in your memorandum of law should match very closely this outline. The outline is critical because it's going to keep your memorandum of law nicely organized, and that organization is going to help it be persuasive and help you get a better grade. Making this outline clear now is going to save you a lot of time later. So let's get a general overview of how your outline might reflect the legal argument section of your memorandum of law. At the top, you'll have Roman numeral 1. That's your first major legal argument. Then your first subheading might be what legal standard is applied to that first legal argument. For example, is the appellate court reviewing the district court based on plain error? Is it de novo? And you want to have some sort of citation to the law that supports your argument as to what the correct legal standard is. Your next subheading might be a relevant three-factor test that courts apply to this first argument. And again, you'll want to have citations to law about that three-factor test. Logically continuing then, a subheading B.1 could be why your client satisfies the first factor, B.2 why the client satisfies the second factor, and B.3 why the client satisfies the third factor. And for each of these subheadings, you've got citations too, because these citations are going to reflect the law and the facts that you have from your case chart. And you might have a third subheading in which you talk about why the adversary's argument is wrong as to this first major legal point. This type of organization is really logical, and it's going to help you get a better grade because it's going to be persuasive and clear to the reader. This is not a good outline. If you just have a list of things you're going to talk about some important point, then I'll talk about another important point, and then I'll talk about why my client should win. This is really just a jumble. It's not going to work. You're going to end up with a mess and a much lower grade than you might be hoping for. At times, you might find it really helpful to create what I'm calling a horizontal outline to organize your thoughts. So for this horizontal outline, I have what you would probably recognize: issue, rule, application, conclusion, and maybe some notes too. And so for example, let's say our issue is, did the court commit some sort of reversible error by allowing the peremptory challenge to stand? Then you want to put down the peremptory challenge should stand where the prosecutor articulates a race-neutral basis for exclusion, and you might have a second part to this rule where a relationship with the defendant is a race-neutral basis to exclude a juror. And you'll want to have your citations here in full for this part of your horizontal chart. And now you can put in your application specific facts that relate to each part of this rule. So if a peremptory challenge stands when the prosecutor articulates a race-neutral basis, well, we'll have a citation to the record where the prosecutor articulated a race-neutral basis to exclude the potential juror. If the rule tells us that a relationship with the defendant is a basis to exclude a juror, then in our application, we'll put exactly where, from the record, we see that the potential juror was excluded based on a relationship. And then finally, you can put down your conclusion, any other notes you want to put down, as to why the district court constitutionally or unconstitutionally allowed the prosecutor to exclude the juror. The horizontal outline is a great way to clearly and precisely organize your thoughts, and then you can put it all into the vertical outline. So let's look at a more specific example as to how we can outline our legal argument section. And our first major point from this sample assignment was denying the defendant's Batson challenge based on racial discrimination. Now, this is the first point. We're only going to discuss issues and sub-issues related to the exclusion of the juror based on racial discrimination. If we put other points within this point, it's going to be confusing. So everything in point 1 is going to only relate to the Batson challenge based on exclusion of the potential juror based on race. So let's continue, and again we are focusing on the sample assignment referred to earlier in this video. And we'll say that our first major point is that the district court correctly rejected the defendant's Batson challenge based on the prosecutor's alleged racial discrimination. The first thing we might want to put down is a subheading on by what legal standard this decision should be reviewed. And a logical second subheading would be the Supreme Court process that we learned about, in which first the defendant has to establish a prima facie case of intentional racial discrimination. Then the burden shifts to the prosecutor to show there was a valid race-neutral explanation for the exclusion. And then finally we get to the third part of the process, where the court decides whether or not the defendant proved purposeful race-based discrimination. Always as we do the outline, we want to include citations from our case chart which support our position. You can abbreviate anything you want, however you like on your outline, use bullet points, whatever works for you. But I encourage you to include specific citations because you don't want to lose this information, and all of it should already be within your case summary and case chart anyway, and this is going to make it so much easier to eventually plug this into your memorandum of law. Now, we were looking at that 3-step process, and the very first step is a prima facie showing of intentional racial discrimination. So what's a prima facie showing? Well, the next logical step in our outline should address that issue. And in this case, because we're the government, we're probably going to be arguing that the defendant can't make the prima facie showing. And our case chart tells us the 3 prongs of a test to determine whether or not there is a prima facie showing of intentional racial discrimination. Our chart told us that there's probably no dispute as to points 1 and 2, but we are going to argue point 3 about whether facts and other relevant circumstances raise an inference of exclusion based on race. Naturally, we have our citations right in the outline, and it all came from our summaries. And this is continuing to flow nice and logically. As to that third point, well, what are facts and circumstances raising an inference of racially based exclusion? Our case summaries tell us that the court is allowed to look at whether or not other jurors of the same race were excluded, and the Supreme Court said we should look at whether questions asked during voir dire were race neutral or not. Our outline reflects this logical organization because it's going to include citations to the record where the prosecutor allowed another juror, an alternate juror from Rangel, to sit, And it's going to include citations to the record where we think the prosecutor asked race-neutral questions during voir dire. And this type of clear, logical organization is what your instructor is almost certainly expecting when you present your memorandum of law. And the outline should continue in this logical format where in the next subheading, you can address, well, even if the defendant was able to make a prima facie case of discrimination, the prosecutor provided a valid race-neutral explanation for excluding that other juror. And the outline can continue by listing the cases that you'll discuss involving race-neutral based explanations, and then apply the law to the facts of our case where you cite to the record showing how, where the prosecutor provided a valid race-neutral explanation for excluding the juror. And this should look a bit familiar to some of the memoranda of law that we looked at earlier in terms of logical organization. We have a larger heading talking about one major legal point, and then below that we have subheadings addressing each of the components of the larger legal section. By creating this type of logical organization in your outline, you're going to find that your memorandum of law flows so much better, and by doing this outline first, you're going to be a lot happier when we get to writing and rewriting the memorandum of law.